Welcome, innovators. All right, so you've come up with a great idea for a useful product or process. You don't want anyone stealing your idea. If you watched my first misconceptions video, you would know that patent would be the best way to go. The question is, can you patent anything? Hello, everybody. My name is Uk Pak. I'm a registered patent lawyer, and in this video, we will talk about the first criteria for patentability, which is whether or not the subject matter of your invention is even eligible to be patented. Clients will often ask, I can patent anything, can't I? The short answer is no. There was a point in time when anything under the sun that is made by man was eligible for patenting with some limited exceptions. These exceptions are laws of nature, natural phenomenon, and abstract ideas. Now, in the past, these exceptions were not raised very often. However, technology has evolved well beyond what the original drafters of the patent laws could have imagined, leaving the courts to figure out whether these exceptions apply to today's technologies. Unfortunately, this concept has become a very complicated legal issue. Patent practitioners have trouble with it, the patent office has trouble with it, and even the courts have trouble with it. So I won't bore you with the details of how to determine whether an idea falls under patentable subject matter or one of the exceptions. However, let me give you a few examples to give you a flavor of where this patentable subject matter issue is likely to arise. For those in the medical industry and other industries dealing with diagnostic tests, you may be faced with patentable subject matter issues if your diagnostic test merely identifies correlations between certain conditions or treatments and the naturally occurring events that follow from those conditions or treatments, because the diagnostic test is simply describing a law of nature. For example, in the Supreme Court case Mayo Collaborative Services versus Prometheus, the invention was for a method of optimizing the efficacy of a treatment for a specific disorder by first administering a drug containing a specific compound into a patient, and second, determining the level of that compound in the patient. Now, depending on how much of the compound is detected, the doctor would know whether to increase or decrease the dosage. But the court found that once the drug was administered, you were simply determining what is naturally happening, and therefore this subject matter was not eligible for patenting. So, if your idea is related to a diagnostic test, you have to be careful how your invention is described so that it is not simply considered a description of a law of nature. For those in the biotech industry dealing with genetic and other biological material, you may face this problem because courts have found that identification and isolation of genes that can be useful in the detection of disease states is not patentable subject matter because genes are considered a natural phenomenon, even though genes do not exist in nature in isolation. The big case for this example is Association for Molecular Pathology versus Myriad. In this case, Myriad had discovered a gene that when mutated can increase the risk of breast and ovarian cancer. What was incredible about this case was that the Supreme Court stated Myriad's discovery was a medical breakthrough, and even stated that Myriad found an important and useful gene. But the court still determined Myriad didn't actually create anything because technically the gene existed in nature, even though it doesn't exist in nature in isolation. Now, here's one of the biggest situations that triggers this patent-eligible subject matter issue. If you were taking a known business or financial practice and you utilize a computer, for example, by creating an app to perform this business or financial practice more efficiently, you're going to want to discuss patent-eligible subject matter with a patent practitioner because courts have found that implementing known business or financial practices on a computer is simply an abstract idea. The example here is the Supreme Court case of Alice versus CLS Bank. In this case, the patent was directed towards a known financial practice of mitigating settlement risk using a third-party intermediary. But this practice was implemented using a computer as the platform. By considering the intermediate settlement as an abstract idea, the court found that the invention was not eligible for patenting because the patentee was implementing that abstract idea on a computer. The court said if a patent's recitation of a computer amounts to a mere instruction to implement an abstract idea on a computer, that addition cannot import patent eligibility. And the court concluded, the claims at issue amount to nothing significantly more than an instruction to apply the abstract idea of intermediated settlement using some unspecified generic computer. So, dispelling misconception number 2, no, you can't patent anything, even if it is useful, particularly for those in the medical industry and other industries dealing with diagnostics that merely measure observations in nature, which can fall under the law of nature exception. For those in the biotech industry, dealing with genetic and other biological material, which can fall under the natural phenomena exception. And for those in any industry in which a computer is the main technological tool being implemented to perform a known function, which can fall under the abstract idea exception. For those involved in these types of innovations, you're going to want to discuss patent-eligible subject matter with your patent practitioner. Well, that's it for this video. I hope you found it informative and entertaining because it's not legal advice. Nonetheless, I hope you liked it, and I hope you keep innovating in all areas of your life.